There we are. Welcome back, everyone, to House General and Housing. It's still February 25th, 2026, and we are discussing H 772, the landlord tenant bill. And we will be joined by counsel in about 45 minutes. But I thought, it might be valuable. I talked to a number of people who were saying, I'm so close to each of the little things we've been talking about, I kind of don't know where we stand in the big picture. And what I thought I would do for everybody's benefit is I'm going to try to describe the bill generically, what's in the bill overall, so that we can all sort of have that in our minds. As we've discussed before, one way of looking at this, what we've done is we've just taken terms, we've just left out terms like just cause, no cause, for cause, because in current law, every one of them has exceptions, and it's just a sort of a mess. And also I'm not sure these terms help. And instead, we've just focused directly on all the actions that landlords that could be causes for eviction. And one way to think about this, which is applicable to this bill, is we think about issues that arise because of the tenant versus issues that arise because of the landlord. And they're treated differently. So in terms of issues that flow from the tenant, they may not be the tenant's fault necessarily, but there are two of them. One is the dangerous tenant, the tenant who's endangering the health and safety of others. And the other is not the tenant who either does not or cannot pay the rent. So the dangerous tenant came to us. A lot of landlords talked about this problem, but particularly, actually, we heard a lot from landlords who are the nonprofit landlords. And the problem they're dealing with are dangerous tenants who are perhaps dealing drugs or situations that really have made it very difficult for them. The other tenants really are unhappy with the situation, and it's made it difficult, but it's difficult for them to evict them for various reasons. So 772 addresses tenant actions that endanger the health and safety of other tenants. And the landlord or the landlord or the health and safety of the landlord's agent. And it does it by creating a special show cause process, which is faster, in which the landlord can put together under penalty of perjury the reasons that they think it's clear that the tenant is dangerous and what they're doing. And then there's a show cause hearing very quickly. And at the end of the show cause hearing, the tenant has to appear and rebut those allegations. If the tenant doesn't show up, then the landlord gets possession. If the tenant does show up and just doesn't have anything to say, really, the landlord gets possession. If the tenant shows up and rebuts the allegations with others, then it's up to the court. If the court finds that there's really a credible dispute here, the court can order a hearing, but that hearing is very quick. It comes quickly. So that's that deal. And then the other thing we've done, which is very important, that deals with a situation where the tenant is the problem. But what happens if the tenant isn't the problem? What happens if someone is preying on the tenant and has made it clear that they're going to stay in their apartment and sell drugs or whatever, and the tenant is terrified, or perhaps a user or whatever? And what we have done is taken provisions from Debbie's bill, provisions from Ian's bill, and put in enhanced trespass requirements. There was, if you remember, a case which made it pretty clear that under the court's interpretation of existing law, you couldn't issue trespass you couldn't use the force of trespass law against someone who wasn't a tenant but was an invitee. That's the wrong word. Whether the tenant agreed or didn't agree was, kind of camping on the tenant, and that's been changed now. That law provides that it's got safeguards in it. It occurs, we'll get to that, but it occurs particularly where the tenant says, I don't want them, or similar situations. And we'll get to the details of that trespass law. Yeah.
Did we add in anything about when the landlord or their agent is the danger?
I think in existing law that violates the provisions of existing law, which remain unchanged about the obligations of the landlord. But no, but to be frank, I think it would befall the tenant to raise those issues, which sometimes they may not want to do. The non-payment of rent is the really difficult situation. Let's be clear, or I'll be clear why I think it's so difficult. It's the most common, remember the testimony of the sheriff? It's the most common situation. Why is it so difficult? It's so difficult because we are operating in this room when we sit here trying to come up with a compromise that we can all live with. We are operating in a world in which the United States does not have a developed social safety network. In other words, in a lot of other countries in the world, there are all kinds of help for people who are running out of money. At the same time, we have decided in this country, and it's pretty common, there's no question that housing is kind of, whether you characterize it as a fundamental human right or not, it's clear it's important, right? I mean, you can name it any way you want, but it's important. But we have decided that the way that housing is going to be provided is through the private sector. And the private sector has to function as a business financially. If they don't function financially, it doesn't work. They're not going to provide this service. In other countries, the state assists the private sector much more than in this country. In this country, landlords don't have a lot of help. And so it really kind of comes down to this bedrock problem that they have to make their business work. So that contradiction, those contradictions, no social safety net, and increasingly a tight rental market, a rental market where everything is beyond incredibly expensive and getting more so, the lack of state help for various reasons, justified or not, that's what we're operating in. And there's nothing we can do about those things. They're there. Well, it's not nothing. We'll get to that. So how do we deal with this? The way 772 deals with it, on one side, it helps the landlords with a faster eviction process. It may not be quite as fast as some of the deadlines that in some of the bills, but it's faster, a lot faster. Right now, it takes 4 to 6 months, clearly. Remember, we had testimony that 6 months is what the courts regard as what they're aiming for. And quote, 80% of the cases are resolved in 6 months, but that means 20% are not. They take longer. So what we've done is put together a series of deadlines, which substantially shorten that to, I would say, 60 to 90 days. It just depends, but 60 days is the goal. And you'll see that when we keep going, you'll see that there's a 60-day requirement for hearing, to get to a final hearing, the longest one. And there are several other faster ones, but the longest one is 60 days. The problem is, everybody, it depends on the judiciary. We can't get around that. So, but we at least in the legislation are saying 60 to 90 days. We have evidence of what other states do. We are definitely an outlier right now. It takes longer here than in many other states. We're shortening it. We're trying to cut it in half, essentially. We're also advocating for various programs to assist tenants and landlords in an attempt to prevent the whole non-payment situation. And we're trying to do that, and we're doing it by seeking funding in this bill for support for the Vermont State Housing Authority's Rental Arrears Assistance Fund, which is the primary statewide fund that helps with rental arrears, although we have heard, Debbie's pointed out, there are other sources of funds available to tenants. We've also put in funding for the Champlain Valley OEOs statewide, for a statewide landlord and tenant classes on rights, responsibilities, and remedies. And as part of that, I'm sure they'll do not credit, they'll sort of financial responsibility. We're including a funding program for a statewide positive payment credit reporting pilot program so that people can build their credit by paying rent, which they can't now. It just doesn't work that way. And then you'll see funding for rental ombudspersons in the CAP agencies. But there's no question that this is a thorny issue because landlords who can't pay, and in today's rental market, it's not like we have a 6 or 7 or 8% vacancy. We don't. And so when tenants are evicted because they can't pay, they often end up in a homeless situation. And that's costs the state a lot as well. That's why we're advocating for this funding for rental arrears. I think that's one of the most important points of the bill. And if asked by appropriations, when I testify to appropriations, I will testify that that is a very high priority.
You might point out how much less expensive it is than the hotel.
Exactly. I will point that out.
Well, it's not just that. It is also that our system does not support families staying together. So it also includes foster care, children entering the foster care, and the ultimate cost to the system of children entering the foster care, who then have a very high rate of then becoming homeless, then becoming dependent on state aid for the course of their lives. So it's much more than just staying in the hotel.
That's good, and I will say that. Okay. I think I'm just trying to say overtly, this is just a very bad problem. This bill does what we can. A lot of this is out of our control, and it just is there, which is a bad situation. So the other bucket is not tenant-created situations, but landlord-created situations. I'm not saying that landlords are acting badly, they're just acting. These are situations where, remember, the landlord decides not to renew a lease, they decide to convert to a condominium or convert it to family use, or to completely remodel the building, which may again become rental, but at least for these tenants, they can't stay there because of the remodel. These are not prevented in 772, but the landlord, first of all, has to give 3 months notice. That's a long notice period. And it is there to give tenants time. And the security deposit, as we've discussed, at least as this bill is written, has to be for the tenant who's a really good tenant. Remember how I said you can't only make law thinking of the worst cases. You do have to think about the worst cases, but you also have to think about the good cases. We have good landlords, a lot of them, and good tenants. A good tenant if they have to leave and they've taken care of the unit, they should get, under this bill, they will get half their rental deposit back early. So they will have time to roll it over into a new unit. And then, in other words, okay, and then there are provisions of 772 that apply in all cases. Remember, I started off with these two buckets. One is the tenant moving for, like non-payment of rent or the violent tenant. One is that's in the control of the landlord. So the tenant things are not in control of the landlord. If the tenant starts not paying rent, that's not the landlord's fault. It is the landlord's problem, particularly if you're a small landlord, they could lose their building to the bank because they can't pay the mortgage. And then we have the landlord initiated situations that I described, and those are fine too, but we're giving long notice periods and security deposit returned if there aren't damage. Then there are provisions of 772 that apply in all cases. Doesn't matter which bucket it is. In all cases, security deposit is limited to 2 months' rent. In all cases, rent cannot be increased more than once every year. Except, of course, we went through that. If you buy a building, you get your shot at it. In all cases, eviction processes remain confidential unless and until judgment for the landlord, which case they're not. And in all cases, major uncured, or I would say code violations that are not in the process of being cured are a defense to eviction. That's what's in this bill. I mean, that's it. Let me be clear. Here's what's not in the bill. Okay? I'm going to go back before I say what's not in the bill. So in sum, we have these guideposts that we're constantly trying to live within. We have to allow landlords to have viable business or the housing won't be there. I think we have to, my own view, I'm just saying, is, I don't know, how could I know whether landlords will get out of the business under the current law? I am certainly reading that they are doing that, but I don't know. But I strongly suspect they will not invest in more rent. And if they, and that they may be tempted to convert to short-term rent. So under the status quo. At the same time, we have to encourage situations that allow good tenants to stay, or if they can't stay, to move in a reasonable period of time and have some money to move. Okay, that said, let me be real clear about what is not in this bill. This bill does not contain across the board rent control of any sort. There is no cap on rental increases. It does not contain a perpetual renewal of leases where the tenant is paying rent. I can talk about that a little. I'll just say, I don't think that would work without rent control. In other words, I think the two go together. If you provide that if you have a 12-month, you sign a 12-month lease, it really isn't 12 months, it goes on forever as long as the tenant pays rent. If the landlord can raise the rent to any amount they want, they could just drive the tenant out by raising the rent. So I think that rent control and perpetual renewal of leases go together. I will say that so far my research indicates that although there are some cities in the United States that have both rent control and perpetual renewal, there's no state that does. And my research indicates that I used to think that things in Europe were very pro-tenant, and they are, but they do not, none of them, to my knowledge, say that as long as you pay rent, you can stay. What they say is that the landlord wants to remove you, there's very long waiting periods. There is no financial relocation assistance requirement imposed on the landlord. In other words, there's no requirement that the landlord has to pay to relocate tenants. There are, I will tell you from my own experience, if a project or a nonprofit is operating under federal law, there are such requirements. They are limited, but they're there and they can be quite expensive. There's a requirement in some cases that you pay the differential between what was paid before and any new unit that is found. The problem that the testimony and input we've seen is that in Vermont, a lot of the housing that's provided is not provided by landlords with dozens, hundreds, or thousands of units. It's provided by very small landlords who arguably cannot afford that. That was 772 does not contain those things. So that's a quick overview of the bill in terms of what it does and what it doesn't do. And I just wanted to start there, to kind of give, because I know we're just going through it line by line. Nothing is decided until everything is decided, in the sense that we're going through line by line. People can say, well, I don't like this, or I do like that. And then in the end, what really matters is, where are you? Do you think, for me, the choice is, how does the end compromise compared to the status quo? Is it an improvement or isn't it an improvement? And that's the operative question. In terms of ideally when we would vote, I think we will finish going through the bill today. And I think we can have discussion tomorrow. Ideally, I would like to vote tomorrow. Unfortunately, I have signed up finally to go to the Council of Local Governments Housing Conference
Which day are you going on?
Friday.
Okay.
They're flying me out on Friday and Saturday. I hope we can vote tomorrow. I think that if we can't, we can't, and we'll postpone it till after town meeting. But I hope we can vote, but I don't know. And
Is there a time when we could talk about various little tweaks that we would like to suggest?
absolutely, there are two times. One is as we go through, discussing it in terms of the markup. What's our next? What's going to be in the next bill? So an example of our doing that was, well, I can think of two. You raised the issue of what about the dangerous landlord? I think the answer is in its existing law, but you need to get him to
It's
confirm it.
not. I just checked it.
Okay,
It's not.
well then, what do we do about that?
But also another one is, what if your county sheriff's department is
Like, is that-
compromised?
is there
Can we
something
come up
else?
with another?
Right, I think that we discussed
I mean, I
that
have
when you were.
a
I
whole
know.
list of those.
Yeah, well, so one way is as he goes through.
Uh-huh.
Another way is when we discuss, say, well, here's the things I would like to see that we aren't in here, and what can we do about it?
So when would be, just so to get a sense, when would be the last chance to kind of do that? You're saying we would like to be able to. What's our agenda tomorrow looking like?
At the moment, we have 770, this bill at 9 to 9:30. And then we have all tomorrow afternoon. As far as I'm concerned, this bill trumps everything. And if we have to kick
Is that-
things tomorrow, we'll do that.
I need to go and I have a 5-minute, 10-minute long meeting that I have to get to, but I'm right back.
This is, by the way, everybody's going to be doing this more and more because you got to go to other committees. By the way, we did discuss when you were out of the room, the sheriff.
Oh,
We did.
come up with
At
a
the
solution?
moment, the only solution is We passed a bill last year, the year before, that allows you to use any sheriff, not just your county sheriff.
Yeah, our county sheriff, like the, Orange County uses our sheriff. But
Yeah,
I
and the other is.
Because otherwise we'd have to come up
sheriff's
with
deputy-
process servers.
The sheriff's deputy any deputy sheriff can do it. The question is there anybody else who is trained and ready to deal with? Remember, the sheriff only deals with eviction, the actual act of ejectment. Otherwise, it's just civil process. That's the one area where everybody agreed we need somebody who's trained. Question is, who is that? Yeah. Yeah, so I think at the end of today, we'll all know what's in the bill and what isn't. And I think people should be talking about, well, I really need to see this or that or whatever, and see if we can come to consensus. Yes, Debbie.
I don't know if this is really brought up at all, but I think in some of the written testimony that we've gotten, that like including pictures, I know.
All the pictures of how the apartments were left.
Yeah, I mean, is there? I mean, it's a civil matter, but there's criminal destruction done to these apartments. Is there any way to address that?
What were you gonna say?
There'll be a criminal, you'd have to bring charges.
I don't know if there's a crime for wanton damage to property. Only thing I can tell you is actually, Chris, do you happen to know whether there exists now a criminal approach to wanton property destruction? The only thing I will say is one of the problems that landlords run into is that when they operate in the criminal domain, the standards of proof are higher, it's harder, et cetera. I mean, I almost feel like the best thing we're doing is trying to make it easier to just evict people. Yeah. I mean, there's no question that part of doing business, the part of doing business as a landlord involves not just dealing with good tenants, but putting into the business plan the costs of dealing with the bad tenants. And I'm not sure we can do anything about that. That is, it's part of the business plan. What we're doing is saying, no, we're not going to have rent control. Like I said, from my personal perspective, one of the problems that we're dealing with here is we can't control a lot of what's outside of here. We can only change the law and hope for the best and see how it goes and then take it again, another pass. But anyway, that was my quick effort to summarize the bill. I think it's safe to say that it ain't everything. It's some of the things that tenants really would like, we're not doing. Some of the things landlords would really like, we're not doing. I do think it's very important to speed up the eviction process. Yes.
I think it was the lawyer that worked for Chittenden Housing Trust that she advocated to keep no cause evictions in there along with the show cause, and they just talked about a little longer timeline for that, for the no cause.
Right. The
Are you
reason,
doing that?
actually, without calling it no cause, it's in the bill. There is no prohibition on a landlord terminating because the lease is up. There is no prohibition on a landlord terminating because they want to use the building for something else. There never was in the law the ability to just throw a tenant out during the lease. you know. So although the word is gone, the substance is there. Remember you
With a 90-day notice.
yeah, with a 90-day, well, not for non-payment of rent, not for the dangerous tenant, just for terminating the lease. Yes.
Right.
Yeah, that's the give. Because we're not giving tenants rent control. We're not giving tenants the right to that a lease auto renews, which they would really like. I mean, the normal tenant, there are stories we have heard of tenants just being repeatedly having to move their families again and again for no good reason. Yeah, and frankly, I don't think the landlords in this room do that. They don't do that, but it happens.
No, but if you rent to somebody and like they don't even make it through the first month. And then I'm gonna use a 90-day notice, like I'm gonna wait that long to.
No,
get
that's,
it out.
that gives you a reason, that's a eviction that would have.
If they don't pay
clause.
rent, it's quicker. If it's just as quick, if not quicker than current law. But in fact, it is quicker than current law.
I don't know, it's the not payment of rent.
Now, they're non-payment of rent or a violent tenant, it's much quicker than current law. If it's letting the lease run out, yes. I mean, you can, yeah. Another possibility for a landlord is simply not to enter into long-term leases until tenant, for the first, make it month to month for a few months and see what you've got. There are bills, like for example, Saudi's bill and Chloe's bill, I think, have in them perpetual lease. You know what I mean? That is where the lease just renews and renews automatically.
Once. you
But
get-
Saudi has said,
once you
Saudi
get
has said
trial period.
after a trial period of 6
Right.
months.
Mhm.
But we don't have the perpetual renewal in here.
Just adding, it's perpetual renewal with the clause that there are several off ramps and ways to get out of that. Just saying. Thank you.
That's true. Yes, Tom.
You maybe answer previous question as to penalties for destroying property.
Yeah.
Title 13, unlawful mischief. Reads a person who with intent to damage property and having no right to do so or reasonable ground to believe that he or she has such a right. Does any damage to any property that is valued in an amount exceeding $1,000 shall be imprisoned for not more than 5 years or fined not more than $5,000 or both.
I have heard that, yeah, there is unlawful mischief, yes. Whether a landlord would bother, that's what I mean. In the real world, what we're hearing from both sides is the same, which in the real world, a lot of this stuff doesn't function. Because from the landlord side, they're dealing with a judgment-proof tenant. And they just basically know that the best thing we can do is get them out of there. And they're not going to bother to file a criminal complaint or something like that. On the tenant side, they're just dealing with an imbalance of power. They feel the landlord has all the power. If they get the landlord angry, then they'll get kicked out. And so that's, we're living in that world where probably both those things are true. But yes, there appears to be a criminal avenue. Would you like Cameron to look into that?
I just, if it's,
I mean,
I think I'd like to know if it is a reasonably viable option for a landlord to even bother with it, because sometimes we're talking about $10,000 to $20,000 worth of damage. And a loss of rental revenue while you're waiting for a contractor to eventually get there to do something about it. It's there are some instances where it's a bigger.
yeah, I mean, I get,
Yourself.
Yeah.
but you keep going, sorry, I thought you were done. I'm sorry, I didn't mean to. Okay, I guess I just feel like those. Clearly, when the accusation is bigger about something really big, you should have a bigger burden of proof and you have to go through the process. Like, that's just the way it is for all of these things. Like, I don't think this bill is where we will talk about massive crimes that,
But no,
because
it may not be in
we
this
can't
bill, but I
prevent
mean-
it, and we can't create a vehicle of like a remedy beyond use the court system, like there, that's what it's there for. Like in the land, like this is about little tweaks, honestly, like I don't
No,
think we
no, I'm
can
not
do, yeah.
suggesting we put it in this bill.
Oh, okay, okay.
I kind of wondered if there's a different place for them, because that's, most of these tenants don't fall in this category. I mean, most of the, people who are not paying their rent, or.
Are the
they're
majority
not-
of cases.
Yeah, but it's the few notorious ones that keep small renters from going into the business.
Any small landlords.
Yeah,
Yeah, yeah.
small landlords, who could rent one apartment, two apartments. It's not the majority, but
Yeah.
this is the one that sticks in their mind.
Right. Well, I think again, I think the approach of finding that middle ground, just like we are not talking about, the most horrible tenant actions or abuses. We're not legislating how to provide remedies or even prevent those things. We're trying to make the process friendlier to both sides to come to a better agreement so that people are either not left in the street or living in bad conditions or stopping to rent at all. And that's like, we don't want to keep moving the goalposts either as we have this discussion. Like, these are the items that from all of the different bills that were in, like, I don't think that element was even in your proposal to begin with,
No,
right?
she had it, she criminalized some stuff.
Sure, but if you do criminalize something that's already that's
So I
already.
am relieved to find that there is a remedy at law, a criminal for that. I do think it would be interesting to find out if it's available.
So if it's on the books.
Yes,
I feel strongly that we should be able to find a way to add remedies for tenants for how can we work? Okay. Let me back up. This past summer, there were some tenants who were wheelchair users here in Montpelier, and the elevator broke and they were stuck that happened right at the end of the session. The elevator broke and the tenants were stuck in their building, and they were not moved to a place where they could or leave the apartment. Like the landlord didn't move them to another place. And they were in there. I followed up about a month later to see what had happened, and they were still in there. And like, for people with disabilities, like that is not acceptable for anybody. For people without disabilities, it would be totally unacceptable for a person to be locked in their apartment. And yet there's no actual remedy for landlords who don't immediately address a concern like that. There isn't, like, what's that?
Where was this?
Here in Montpelier. What's
Is
that?
that habitability or?
There is no remedy, actually. So a tenant under current statute, from what I understand, a tenant can withhold
rent.
rent, but that's not the point. the point is that people are being held hostage in their unit because there's a lack of elevator repair people in New England in general. And that is not the fault of the tenant, but
It's also not the fault of the landlord.
nonetheless, people are like, if, again, if the person was not disabled and they were held hostage in their apartment, it would not be acceptable. It is only acceptable. And so I'm just saying that it is not acceptable, and it is something that the landlord has a responsibility to the tenant. It's not, it doesn't matter whether it's not the landlord's fault. The landlord has a responsibility to the well-being of the tenant. If we're gonna do all this stuff to protect landlords, we should also be doing things to protect tenants from, we want people to be able to live good lives. And it's, I feel really frustrated about the only remedy provided to tenants being non-payment of rent, because and that's for health and safety issues, when non-payment of rent is fine, but it's not the point. The point is being able to live a safe and healthy life.
Do you have any sense as to what the remedy would be?
In some other states, the landlord has to put the tenant up somewhere until it's fixed.
You mean to
In a
find,
hotel.
landlord has to find housing?
Yep,
Until when?
until it's fixed.
And rent continues or does not? Payment continues or not? Sorry. Yeah, I'm just asking what that piece
I don't know.
happens on that piece.
My friend, her landlord had to put her up in a hotel with her fiance until they fixed some mold issues in the house, but she had to go through legal steps to get him to be able to do that. But she said, I can't live in it. And until it was fixed, and that forced him to fix it. And that's in Vermont.
Yes.
Well, I'd like to know, what maybe would come under fire and safety. Because you could have a tenant, there's no elevator, but you could have a tenant, they become wheelchair bound, they're on a second floor apartment. And does the fire department say they can't be there?
According to the Americans with Disabilities Act, it is then incumbent upon the landlord to provide accessibility for the tenant.
So
You know,
why do we need it in state law? I mean, it's already in federal law, so it applies. I have to promise people know what's in the law. So if it's in ADA and it's also in Fair Housing Act, what would change if we put it in this law?
I'm not talking about
Or
I'm not talking about people with disabilities. I am drawing a comparison for people without disabilities, saying that if you were locked inside your apartment, unable to get out, it wouldn't be, it's not a thing for people without disabilities because it would be unacceptable. And yet somehow it is acceptable for people with disabilities. But I'm just trying to draw a line between, because the people who had been in Montpelier had been stuck in their apartments for like a few months. It wasn't like a week. And so I'm not talking about the ADA. I am talking about remedies for, there being remedies for tenants.
But the disability is a real differentiator, because if a tenant who isn't disabled, let's say they're locked into their unit, well, it's rather inexpensive and easy to fix that. It isn't inexpensive and easy to fix a broken elevator. It's completely different order of magnitude. It's just a much worse problem. I mean, I'm not saying it shouldn't be addressed.
But I'm just
that
saying that like I guess in general, what I'm saying is that we fail to address the obligation of the landlord to protect the well-being of the tenant. So we have all these things about damage to the apartment, but we're not adding in anything about the well-being of the tenant. And
Well,
that goes with safety
are-
of the tenant with regards to the landlord or their agent. And it has to do with there being something beyond just the ability to withhold rent.
A couple of questions have come up. Did you go ahead? You had your hand up.
Well, I had a question of isn't that all in the tenant's rights? That it covers that?
I
Let's
just looked at
ask.
it and I didn't see that.
Cameron,
I don't need to go on, though. I mean, it's not in there?
I just read it and I didn't see, because Mark said it was under the landlord's obligations, and I read that part and I didn't, it said tenant is allowed to withhold rent.
I think the question, I'm going to translate this for a minute into a legal question for counsel. A couple of questions have come up. Are you ready?
Yes, sir.
Okay, one is, does habitability, which agreed only contains, the only remedy in habitability is withholding rent, right? And you can't, while someone's withholding rent, you can't evict them, which means that either they're occupying it for free or you're fixing, right?
In that section, for the record, Cameron Wood, Office of
Thank you.
Legislative Counsel. It is 9 VSA 4458. The tenant may withhold rent for the period of noncompliance, obtain injunctive relief,
Okay,
recover damages, costs, and reasonable attorney's fees, or terminate the rental agreement.
okay. So, that's the law there. Also, what about the problem of what can a tenant do if a landlord is dangerous? You know, we have a section trying to, Elizabeth, respond to the question that you asked here. I don't want to reframe it away. She's asking, we were out of the room, look, we have these remedies for tenants, for the landlords, for a dangerous tenant. What about the dangerous landlord? Somebody who is endangering the health or safety of the tenant. What are the remedies available to the tenant?
Yeah.
When
When I was 18, I had a landlord, like I rented an apartment in Burlington and the landlord and property manager would just like come over and be creepy and like I was like a young woman alone and they would be like sometimes in my apartment when I wasn't even there waiting for me to come back and things like that. Don't worry, my mom handled it, but those kinds of things, what is a young woman to do?
I think it would be interesting, counsel. I think this is a legitimate concern. I think it would be interesting for you to investigate it. If you wish to answer off the top of your head, be my guest.
I don't see anything in the residential rental agreement chapter that would address it.
Do they have an obligation to provide, there's that series, there are those obligations of the landlord. Is there any obligation that they provide safe housing?
I would want to look in the rules of the Division of Fire Safety to see if there's anything in there about like that. There's nothing in statute in the habitability section. Where I was going to go is, I mean, if the landlord, you know, could you go get a restraining order against your landlord? I'm assuming.
Yeah, probably.
I was gonna say, I'm assuming yes. I imagine that puts you in a very difficult position when you're having to, you know, the person, you know, has the ability to, you know, remove your tenancy at, you know, the conclusion of your rental agreement. So I know that puts the tenant in a, the power dynamic.
Right.
You know, situation is slightly different, but I'm not aware of there being any specific tenant remedy in statute about just there being a bad landlord.
Yes.
And so I guess one of my questions is, could there be a show cause hearing for our landlord?
In this type of situation, you're saying, like, if a,
I'm saying that if a tenant accuses a landlord of, you know, I don't know, some sort of inappropriate behavior that does threaten the safety, the same as that does threaten the safety of the tenant, the same as the landlord could say for the tenant. Couldn't the tenant make the same kind of claim against the landlord that they have to then show cause? And then if they do show cause, you know, they like get all their deposit back immediately or some, I don't know what it is.
so I would think about it in this way, you know, the tenant, again, you know, I think a tenant is gonna have whatever rights and remedies an individual has against another individual. So, you know, if you're harassing me or stalking me, or, you know, I want to go get a restraining order against you, the individual tenant would have whatever rights that other Vermonters have against other Vermonters in that space. What you may then want to consider is whether or not you want to expand on the anti-retaliation provisions in here. So if an individual goes and gets some sort of restraining order against a landlord, and there is some sort of retaliatory conduct against the individual because of that, that the individual would be eligible for damages or something to that effect. I think that may be the most straightforward way of trying to address what I think is the concern.
Is that something that people are asking to have in the bill?
Well, it's something that Elizabeth has brought up. And the question, I mean, I would certainly be interested in your pursuing that.
So you would like to see
I'd like
language?
to see what it would look like.
So I haven't, in the different testimony that we've been emailed and sent, I haven't seen anybody name this as a situation, but hypothetically, what do you do if it's the landlord selling drugs?
Landlord, what?
If it's the landlord selling drugs?
Well, or providing,
It wasn't the landlord, it was the tenant who was letting people come in and use his apartment. And they did give one of the persons a restraining order, or no trespass. But I mean, it.
Well, if the landlord's selling drugs, just call the police.
yeah.
Well, I thought.
Then you have to.
A building was taken back, didn't the feds take a building over in Rutland?
Yes. There is.
Because of their
But
oh, I don't, activity
Yes.
on the very same token,
was empty.
It's
empty.
when we're talking about providing safety to all tenants, one of the scenarios that I thought of was I think I've mentioned before, a building where I've been contacted several times about this building, where there are children in the building and there are neighbors who are either using illicit substances or licit substances, but exposing the children in the building to behavior that's not appropriate for children. And So what if the landlord is the one doing that? It's not, they could say it's not illegal, but they, you know,
Well, that's why I'm wondering whether.
whether there's a,
Would it be overbroad? I'm just wondering whether it's possible to include in the list of things the landlord's obligations. Remember you showed us that there are provisions, they're not in this bill because we didn't amend them. The landlord had an obligation to provide a, habitable, could we add, and safe housing situation.
Law abiding. Yeah, I don't know, that's complicated.
I think that my instinct is, of course, to be like, yes, we need to
Right.
make sure that that's like such a laudable thing. But I also have this sense of like, there are other systems in place for those things, unless this is a wraparound service situation, like if you're just in charge of making sure that the place is habitable. If you're saying we should be putting some kind of, like, what remedies or penalties
I'm
extra
saying,
than like a regular court system would you suggest?
I am simply saying that if we are focused on safety for everybody, it should be regardless of who is perpetrating something that is unsafe.
The problem is the show cause hearing, which by the way is a very common, unfortunately common situation. The show cause hearing as it is drafted now, the remedy in the show cause hearing is eviction. If there were a show cause thing of some sort, what for the tenant, for an unsafe landlord, I'm not sure what the remedy would be. That isn't already in law, in law.
Yeah, I mean, I think this could be like a judicial. Like, I just don't know if this is space.
It could be something like the tenant immediately gets all their,
I don't, okay, yeah, I don't,
well, if the landlord's able to. I don't understand why we can't address the power dynamic on an equal footing. Because we are, what?
I agree.
I agree, and I want to just hear how, like, what that would look like. That's what I'm trying to.
I
That's
don't
what I'm
think
trying
it
to
should be a
understand
punishment
further
that we
than-
decide. Like, I don't think it should be our committee being like, then you get this or that. I think that's something that a court should decide. Not,
And so maybe it should be the same for the tenant.
That is what.
it is,
That
how is
is
it
the,
not?
I thought that was the perspective.
Well, no.
Because
we
we're
are-
offering eviction as
we're offering-
a,
I understand, but I get what you're saying, but we can't give someone a bonus because that's not I don't think it's the legislature's job to give someone a bonus if they're have a landlord abuse them. That's where the court should come in and decide what that punishment should
Could there
be.
be an extra protection is what you're saying? Can we add a layer of protection? Is that?
I'm saying that if we are going to claim that both sides of the equation have the same level of power, then we should treat both sides of the equation with the same level of power. So not
But they
just,
don't.
if one, I know,
They don't.
Right,
And
and
there's, unless you can think of something where they would, the landlord has the upper hand and more power because it's his or her dwelling and renting to you.
Well,
So that shifts the power right there.
We have, I just want to make clear, it's not like we have not addressed this issue at all. We are saying that the landlord, the current law says the landlord has to rent property that they maintain as habitable.
Mhm.
We have said that if the landlord tries to evict someone for non-payment, that it's an absolute defense and in fact will dismiss the action if the landlord is not providing a list, is not providing a list of things.
Mhm.
So we are focusing on the law as it stands now, focuses on the need of the landlord to provide the tenant and the right of the tenant to have habitable environment. And I think that that's protected by this bill and by current law. I think I would like to know a little more about what tenant remedies are, Cameron, for as in common with other Vermonters, for a landlord who is dangerous or endangering the safety of the tenant or others. And if you need time to look at that and think about it, we'll give you 30 minutes.
No, I mean, I just think that that's a real judicial question. I don't think that belongs in this bill.
Well, I would say this way, and I've tried to pull up the code and I can review it. Probably while you're on the floor. Somebody. But I would just restate, what I stated already, which is you as a tenant have the same remedies that every other individual has against the bad actions of another person.
Right.
There are sections in here in the residential rental chapter about retaliation, and that is where I'm kind of potentially advising you.
Yeah, we should.
If you wanted to include in there something about, anti-retaliation against somebody who
Sure.
takes steps.
I think that's where I'd like to see what that is.
Right, I agree, but I, right, exactly. I don't think it's our job to take it further than what the law already states for human beings.
Okay, well, I think I would like to see, in the spirit of what you've heard so far, I would like to see just provide information on options for strengthening the retaliation law. And then I think we should, at this point, take advantage of your presence to continue our review of the bill.
Can I
You
just,
mean the next section?
can I just tell
Yes.
us? I have a relative that, in her building, in the, contract, it said if they were going to send anyone into the apartment to do work in the apartment or assess it or whatever, they had to be notified 48 hours in advance. And people came.
They do.
Well, people came to her apartment and were coming in,
Sure.
and she just happened to be home. She had another safety element, and then she found out that it was happening to other tenants. So she decided to move out and she got her full deposit back.
Yeah, no, that same
Yeah.
thing happened to me, like I said, when I was a young kid, and we dealt with it by saying that they broke the law
Great, you know.
and the agreement and got our money back and moved out. It's not good.
No.
So finally, I'm just trying to find, so the remedy on the landlord side is to basically end the contract, right? When there's been some kind of breach like that. Are you saying that you would like a tenant to be able to end a contract as well? Or are you looking for something beyond that? Because I don't know that aside from the retaliatory, like, does that make my question make sense?
Yeah, I get it.
So this is my proposal is here, and I'm not trying to answer the question, Rick Dodge, that was directed at that same
Can you make it
particular,
a little
but
bigger?
this is my,
When you make the volume.
again.
I didn't know if you heard.
So, this is primarily designed about an individual who's made a complaint of a violation or who, has complained to a government agency. It's saying that the landlord cannot retaliate by establishing or changing terms or bringing or threatening to bring action against the person for these things. So that would be, and the tenant is entitled to recover damages and has a defense against a action for possession. And then the next section is except for non-payment of rent, there's a presumption that it's a retaliation if you bring a termination action within 90 days. So that is my recommendation if you're, wanting to try to add something would be adding in here that it would be retaliation to change the terms of the rental agreement or to threaten to bring an action against someone who has filed some sort of, civil or criminal complaint against the landlord. And there's at least some level of protection to the tenant, which would include damages if they brought a case and won. But outside of that, what's the protection from?
Well,
the
I
tenant? It's the
would
same
like to
protection
see,
that-
I think you should give us language. And I think you should go on.
Okay. Back to amendments 1.1 for 772. We are on the bottom of page 17. And we are moving into this new,
Hey, I've got something right now. You gotta take just cause out. 4861 on page 17.
okay. What would you like it to say?
Issuance of process by superior judge.
Right, so there's already a section titled that or similarly titled. So this here it's a fundamental question of how you all would like to proceed. There is a subchapter that deals with ejectment.
Yeah.
You're creating a new subchapter dealing with a certain level of ejectment, so you need to distinguish them somehow. So just cause is the most frequent term I have heard being used here, and that's what was being proposed by the individuals proposing this new subchapter process. So,
But this whole process, remember, initially, language that came from the landlord side created a whole process that was parallel to the existing process because they wanted to maintain a no-cause process. We don't want to do that. That's why we don't want to once we start using just cause, then people are going to want no cause.
I understand that, but I'm saying that you have this process that exists. It's superior court ejectment. It's a subchapter that governs how you eject somebody. And what you're doing is you're adding a new subchapter for a subset of those. And so
What's the subset?
the new subchapter is for termination of, or for non-payment of rent and for failure to comply with material terms of the rental agreement.
Okay, so it's specific to that. Okay, and it's faster, right?
Correct.
So call it that.
Call it what? I'm not trying to be flip here. I'm saying this is the current chapter. It is superior court ejectment, issuance of process. So I can't name it the same thing. It has to identify that you're creating a new ejectment process for a specific thing.
Well, I know, superior court ejectment for non-payment of rent or in danger to tenant. So, I mean, danger to dangerous tenant or something like that.
Oh, so you're saying don't have a label
Yeah,
of just cause, good cause, or whatever?
I mean, once you get back into just cause and no cause, we are going to have a huge political problem.
So, and I will potentially have to give it some thought.
Oh, good, okay, give it some,
We don't have much time.
don't give it a lot of thought.
No, I'm just thinking like,
You got to vote tomorrow, yeah, right.
if we're voting tomorrow, like, can't be like, this is getting
Right.
a lot of revision and a lot of time for Cameron
So
to think of me.
I will see what I can do this.
Okay, all right.
I could think about it.
Okay, so this, as I just was showing, I mean, a lot of this new subchapter is mirrored on what is currently there. And so this is what I meant when I said this subchapter is limited to, there on lines 15, it's limited to a termination based on non-payment of rent or a termination based on the B.
I'm afraid it's going to screw this whole thing up.
No, I can't.
And so, it's setting up this new subchapter for this.
Right,
And so then we get to the next section, which is mirrored on what's currently there, and it says that the process issues as a summons, requiring the defendant to appear and answer to the complaint. There's a slight change there in the yellow, just clarifying, this was based on some feedback from the judiciary witnesses, it's my understanding that the complaint has to state that the defendant, this is on line 5, defendants in possession of the lands and tenements in
Yeah.
question with a description thereof of those lands and tenements. Now, I've highlighted trial by jury, because this
So
initially
also,
said,
oh, right, yeah.
right, it initially said that neither party shall have the right to a trial by jury. There are potential constitutional concerns there, because there is a provision in Vermont Constitution which guarantees a right to a jury trial in certain instances based on the language. So my recommendation to you, if you don't want any constitutional concern with the language, would be to keep the right to a trial by jury. I can't guarantee you that a right to a trial by jury is guaranteed by the Vermont Constitution, because there hasn't been a court that has said that.
You mean there's no court holding it in any civil situation or just,
In any ejectment act case, there is no case that I was able to find in Vermont where the Vermont court states that you have a right under the Vermont Constitution to a trial by jury. There is a court case that seems to imply that you do not, because it was stating in the case that the individual didn't have a right to a trial by jury because there was no material fact in dispute. That was all. So it's not a
if there was a case that said what again?
There's no-
that the individual who did not raise the issue did not have the right to a trial by jury because there was no material fact in dispute in the case.
Right.
So that's
You mean
just,
by implication, if there had been a material fact, maybe they would have.
Exactly, but that's not what the court said, so I
Right.
can't
so
tell
it
you.
was, it was
that.
saying based on just a procedural,
Right.
like,
I will
you
just,
needed to show these, you need to show some facts.
Right, by saying that statement, it's an implication that if there are material facts in dispute, an individual may have the right to a trial by jury, but the court didn't say that. And they haven't held that, so I'm just telling you, it's an open question. If you remove it, and I'm a tenant attorney, it's one of the first things I'm going to argue when I bring the first case is.
you mean if we leave it? Oh, if we
Yeah,
remove
if
the
we-
right.
If we
If you
remove the right.
remove the right to a trial by jury, so I'm simply flagging it for you all, and I'm telling you that I can't guarantee you what the outcome will be.
I will tell you two things. One, I had a conversation with counsel. My reaction was, I mean, what he's saying is you can take the right to a jury trial out. And you will get litigation, to find out whether it's constitutional.
And will the litigation be by jury?
I don't know. No, obviously,
No.
someone will ask for a jury trial. It's not, they'll just make a facial claim against the statute. They don't have to, then, that anybody could bring it, legal aid to just bring a case to test that issue out. I was accosted in the cafe by someone who said, "Oh, looks like you're taking on the Vermont Constitution, aren't you?" And said, "What do you mean?" I said, "Well, right to a jury trial. That's just, I have a friend who's a tenant attorney," and he said, "Man, they just gave me what I need to litigate." So I think the risk is there. It's, I think, up to the committee whether you want to leave the right to
No.
jury trial for now or whether you want to take it out. You see the risk. That's all.
Just
Yeah.
to clarify for the committee, it says Article 12 of the Constitution says this. Trial by jury, Article 12, trial by jury to be held sacred. That when any issue, in fact, proper for the cognizance of a jury is joined in a court of law, parties have a right to trial by jury, which ought to be held sacred.
So everything should be jury trial if someone wants it? Is that what you're saying?
Issue.
No, and let me pull it.
I mean, everybody can read this thing till they're blue in the face.
Yeah, I need to,
To blue in the face, but I think that you can play lawyer, but all our lawyers telling us is that
Yeah.
it's uncertain.
yeah,
And that,
and then if we're
that
not
people have,
lawyers-
there's one court case on it, which held that there wasn't I guess what they looked is they said when any issue it in fact is joined. They decided if there's no issue in fact, then it's no right to a jury. The implication might be when reading this is if there is an issue in fact, you have a right to a jury, but
So right now, what are
It's
the
not
non,
impossible in our situation, Bill, but there might be an issue in fact, in which case they should have the right.
yeah,
Is this going to judiciary?
well, I hope it's only
There's
a
gonna be-
flyby. It's
But
only
there's a
flyby.
lot of pieces that are gonna have to be, I'm just really concerned about the timeline.
Me too.
Because
Well,
this,
the-
there's a lot of things in here that are under their jurisdiction.
The,
And we're not lawyers or judiciary people.
So are you proposing that we strike it because it's gonna hold them up with another
No, I'm not,
question?
I'm suggesting that we trust our legal experts here.
well, our legal expert is saying, recommending we leave the right to a jury.
Then we'll leave it.
So then we have to strike this language.
Yeah, I agree.
And I just want to make sure
What
you
did you
know,
say,
I'm
Tom?
just flagging that if you remove it, it's a constitutional concern. If you don't want the constitutional.
I don't want a
concern,
constitutional concern.
By the way,
Everybody has the right to.
I agree with is that they don't have to take.
I know, but
We'll see.
We'll
There'll be a fly.
I have been working on a bill right now that's gone to 5 committees. And every single committee, even though it's not in their section, has an opinion on everything and wants to talk about every piece.
Right,
And it's been a lot. And so
Okay.
I just worry.
okay, all right, so go on. The consensus is leave the right to a jury trial in the
That's
bill.
what it says in the law, then that's what it says in the law.
Okay,
Okay. Moving on, answer. So this is for the ejectments that are brought under this subchapter. The defendant shall file an answer within 14 days after service of the complaint. This is a reduction from the rules of civil procedure, which is 21 days. If I recall, I think 14 may be more than it was initially when it was introduced, but I don't have that right in front of me, so I'm going to keep us moving. But right now, that has 14 days for the tenant to file the answer to the ejectment action that's brought in court. The answer shall be accompanied with an affidavit setting forth the particular facts. That's the similar language that's in the other chapter. So moving to the sub C. If the complaint is based on a termination under sub A, which is non-payment of rent, the defendant may cure the action by paying all rents owed, court costs and service fees by the answer date. If payment is not received by the answer date, the defendant shall lose the right to cure the complaint as a matter of law. Understanding is there was some concern about this time period raised by the judiciary because it is, you have the right to cure it by the answer date. So you file the complaint, you have 14 days to file that answer. So that's when you would have to cure.
which is sooner than it was. Right now, you can cure it all the way up to judgment, can't you?
My understanding from our conversation based on the testimony you heard, yes, sir. I mean, there's nothing prohibiting the parties from reaching a settlement agreement.
But I mean, isn't it true that under current law, if I don't know that a tenant comes into money and pays the back rent and all the costs, the action's dismissed.
I assume it would be, but that's a question.
Not
of issue.
necessarily.
I don't think there's anything in statute.
Because they've already broken the,
I just don't know.
I don't know. Yeah, I don't know.
I mean, you could settle, but still evict.
But now it
Right.
puts it for the answer.
I mean, that could be part of the settlement decision, but it's not.
Pages, oh my God.
Okay,
All right,
as my understanding of this C is it's going to give the tenant the legal right to cure. As it says here, you lose the right to cure as a matter of law. So after this date, if the
Yeah.
tenant has not cured it, then the landlord is not obligated to accept it after that date. It would become a negotiation point among the parties.
Right.
Happy to answer any questions or spend more time on it if people are confused about what I said. Sub 2 here, upon receipt of the answer to the complaint based on the termination under 4467A or B1. So A being non-payment of rent, B1 being failure to comply with the material terms of the rental agreement, repeated late payment of rent, not giving the landlord access, not following the lease agreement, etc. The court shall set a final hearing date not later than 60 days after the date of service of the complaint, absent good cause.
this was in the original bill. It's 60 days. It's an important date. Judge Zoning was not happy about that, but did not have a correction other than saying, give absent good.
Yeah, this is like the court, giving the court an out for
Right,
going
yeah.
beyond 60 days.
Yes.
It could be giving the parties an out either. It just says good cause, good cause.
Oh,
could
so-
be-
so-
But they'd have to,
Party could be
Yes, ma'am.
very sick or
Right.
whatever, okay.
yes,
Kevin, with the lease for a rental, is the lease more? I can't find another section, in favor of the tenant or the landlord, or is it equal? Meaning is the protection, is that lease protecting also equally the tenant?
It's gonna depend on how the lease is drafted.
Yeah.
I mean, the lease is a contract between the two parties. Depending on how it's drafted, you're gonna argue that it's more favoring to one party over the other.
although I always think of a lease as protecting the tenant
Me too.
because the tenant, it means the landlord can't throw them out.
Mhm.
On the other hand, if the tenant, theoretically, it means that the tenant is stuck for the 12 months too. They owe the
Yeah.
rent, but in most cases, if the
Yeah.
tenant flakes out and leaves, the landlord doesn't have much of a remedy.
I mean, I would echo that. That's probably one of the biggest legal implications of having a written lease is the landlord cannot terminate the lease until the end of the term. They still have to provide that notice period. The notice, even the current statute, the notice period is longer if you do not have a written lease, but it can happen at any time. Whereas if you have the written lease, the landlord can only terminate it at the conclusion of that written lease. So that is one of the mechanisms that would be protection for the tenant.
Okay,
Can I ask a question?
Yeah.
What happens if a tenant wants a written lease and the landlord refuses to provide it?
nothing, well, the landlord cannot rent from that. The tenant cannot rent, but that's the only.
They
there
don't
is no
have, they
obli-
don't have, there's no
there is-
obligation to
There's
give
no
them,
obligation for a written lease, which is in
We're
some of
not
the other
putting-
bills.
but we're
Yes,
not, that's not in this bill.
that's not in this
We're
bill.
not adding it.
Correct. There's no obligation for it in writing, so it would just be a verbal agreement.
Handshake, whatever.
As soon as payment is given.
Yeah,
Or
the
you can,
contract.
or you can prove through an email or witnesses, you could show that there was an understanding that I was gonna rent from this person.
There are other ways to prove.
Aside from a written contract, yeah.
Yeah,
Okay, so back here, we're in this new section, new subchapter. As a default provision,
Mhm.
which states that if the defendant fails to provide the written answer as provided, so if the defendant doesn't provide the answer within that 14-day period, plaintiff shall be entitled to possession. Plaintiff shall file a motion for possession based on the default and shall include an affidavit that provides proof of service to the defendant. The court shall decide on the motion within 5 days after the filing by the plaintiff, absent good cause.
Yeah, we kept a short time period here. It's not quite as short as in some bills of 3 days, but
This
we,
was the compromise
yeah,
language.
this was a compromise and giving Zone A something, yes.
So the next section is about the show cause hearing. If the complaint is based on termination under 4467B2.
That's,
So-
that's the tenant that's
Violence.
silence and, right, endangering, yeah.
Court shall set a show cause hearing within 10 days after an answer is filed. Absent good cause. If the defendant fails to appear, the plaintiff shall be awarded possession. At the show cause hearing, the defendant shall provide a rebuttal to the facts. There's been some minor tweaks here, just trying to I think massage the language to alleviate concerns from the judiciary.
Right.
Testimony that you received. So at the hearing, defendant shall provide a rebuttal to the facts supporting determination claims. Moving to the top of the next page. Parties may rely on affidavit evidence during the show cause hearing made under the pains and penalties of perjury. If the defendant makes a showing of live testimony is required or on the court's own motion, excuse me, determination, then a final hearing can be ordered. And then the final hearing has to be within 21 days after the date of that show cause hearing. So you go to the show cause, court says need to have in-person testimony, that has to happen within 21 days.
Yep.
Okay, so then the next, if the court finds the plaintiff is entitled to possession, whether by default or after a final hearing, plaintiff shall have a judgment for possession, including damages and costs. And then we have the writ of possession shall issue on the date of judgment and direct the sheriff to serve the writ and not earlier than 14 days will put the plaintiff in possession. So similar to the 14-day period under the current construct. Landlord may dispose of any personal property remaining in the dwelling unit without notice or liability, same lead-in language, upon the landlord being legally restored to possession of the dwelling. I'll probably amend the section earlier to follow this, so they're consistent, but it's the 14 plus 0 timeframe that you all discussed. Okay, now trespass orders. So we're moving into this section about trespass. I did do a little bit of digging based on some questions that you all had. You don't need to go to a court to get a trespass order. You as an individual can file a notice against trespass to anyone.
Mhm.
You don't need the sheriff to deliver it.
Okay, Elizabeth, when you were, not here earlier, we talked about if a sheriff can't fill the duties like in your counties, what would happen? So I think this addresses it. Right, Cameron?
It's one.
One of them.
This is-
Yeah, when you're serving papers through the civil procedure process, it's not required to have a sheriff do it. The only thing in statute that I believe we've looked at where there's a requirement of sheriff service delivery is that writ of possession. That final judgment that.
So I'm saying this section would help alleviate what's happening.
But you have to be in possession, right? Yes.
I think when, the lawyer for CHT was testifying, she said to put that trespass, connect that trespass order with the writ of possession.
That's what
This is doing that?
Thank you.
Bless you.
Okay.
yes, Tom.
Just, I know we talked about this at length, I just want to make sure. The plaintiff issue order against trespass for the entire premises, is that clearly referring to the whole property or just the unit? What is the premises?
The premises. Premises is the definition in the residential rental agreement chapter, and it, may be worth it if you want to define it as that as that, but the premises means the dwelling unit, its appurtenances and the building and the grounds, areas and facilities held out for the use of the tenants generally and who use or whose use is promised to the tenant. So it's, you have the dwelling unit. And then you have the premises where that dwelling unit resides.
Cross lawn, gym, whatever else. What
And
about?
the premises would be the wider.
Okay,
the
would that
broad-
include the other units?
Yes,
Okay, so I want to
Dwelling,
make sure they off the property.
it is the building, so it means the dwelling unit, its appurtenances and the building. So,
Okay,
okay, so then you get into Title 13, which is where unlawful trespass exists. And what I've done here is I've combined the language that I initially drafted up. And then I've also added in the language from, I believe it's H 728. What I might
that's the
do,
Eaton's bill.
what I might do in preparation for tomorrow is simply combine these. So it's not two separate subdivisions, but I need to run that by our judiciary. team,
Okay.
just get their immediate feedback. But nothing has changed in the language. It's highlighted because we've just incorporated the language from Representative Goodnow across the hall. And if you all recall, this is trying to address the circumstance where somebody's been ejected. They're given a no trespass order. Separate from that, this language in 728 here that's highlighted is being able to give a no trespass order against someone who doesn't reside in the dwelling unit if the tenant consents to it, if the invitee is subject to an order violating the lease agreement, or the invitee has violated state or federal law while being on the premises. Okay. Oh, my apologies for your preparation, Mr.
Okay,
Okay, so that's page 23. Now we're moving into the ejectment records sections. And if you recall, I mentioned yesterday when we first started, I'm still trying to do a review of this. So if you are willing to allow me leave, I will walk through this tomorrow with you. That is
Hey, I just want to tell people what the attempt here is. Remember, there were, well, first of all, there were people besides, there were a bunch of people who had access, even though it was confidential, there are a bunch of individuals who had access anyway, that weren't just the parties and their lawyers, like legal aid, legal services, and others. We just took that out. All it is the parties and their lawyers. And the second was, the hearing was open. Point was made, what's the point? If the hearing is open, then everybody knows, so that's out. And then the third was exceptions for a whole bunch of people for, unrelated to the need that underlay this and that. So all those exceptions are taken out. It's just simpler. It's a simplification. And I asked counsel to look at other areas which are confidential and,
And I have some information. I'm just needing to sit down and kind of do some
Right.
of that crosswalk. So. And again, I want to just be able to go back through the sections. I removed some of the things, Mr. Chair, as you mentioned, and I just need to go back to a fine tooth comb to make sure that it's.
and if there's an ejectment or a writ of ejectment, judgment for the landlord or writ, confidentiality disappears. In other words, if the landlord brings an action and for one reason or another default or whatever, they win and they get a writ of possession. As soon as the writ is issued, it's not confidential. Yeah.
Did we already talk about the possessions, like the junk? We did already go through that?
Yeah.
Okay, I just had one question about that
About the,
stuff, their stuff.
Yeah.
Can you clarify, so the bill says that a landlord can dispose of property. Does disposal of property include taking property? It does.
It could, yeah, I mean, it is. I think the best way to understand it is the landlord, it is theirs to do with what they
Everything in
choose
the-
at that
yeah.
point in time.
Okay. Is that something that needs to be, should? It wasn't, that wasn't clear to me in
Okay.
either the bill or the current statute.
So I'm just trying to get to where we discussed it, so I just.
Debbie, didn't you say that usually landlords store it? Why do they do that? Because they can't get rid of it all at once.
We might not have a dumpster ready at the time.
Well, keep in mind, this is where we got to a lot of the confusion where under current statute, as I read it, when the landlord is restored to possession of the property, they have to keep all of the tenants' possessions that are in the property for 15 days.
Right.
Before they are legally allowed to dispose of it.
I know.
Maybe throwing it away, maybe giving it away, maybe keeping it.
Right. But not under the
Like
revised.
this, it would be immediately.
Right. Well, just to note, you think that. I think that.
I'm gonna further clean it up to
Okay,
match what's
okay,
below.
but, all right. Okay,
It's under all of this stuff, what if the tenant during this process, this court stuff, what if the tenant moves out and so we never get to
yeah,
that?
then you just get, you get the judgment and then the sheriff can come out. The sheriff. When do you get legal? Good question. Let's say the tenant leaves, you give them the notice and then 5 days later they move. You don't need an order. You just, you don't, if you haven't had to file an ejectment action, it's yours.
Well, I
And
think
it's
it's let
left.
me sure, are we talking about a situation where where you had brought an ejectment case, or are you talking about where somebody has abandoned the property?
No, we're talking about abandonment, you're bringing in a case, they have to answer, you're going through that whole process. We're taking it right to the end of getting a writ of possession. But what happens if they leave during this process?
You have to get,
14 days since.
you
being
have to get a writ of, first of all, I think once the ejectment action, unless there's once you begin an ejectment action, one way or another, you're gonna have to have a
You get a
judgment or
writ.
writ, yeah.
Yeah.
Writ of possession.
But when you're talking about things being sealed.
Oh, that's
Different.
sealed, that's different. It's sealed from the day you file the complaint until the day you get your writ of.
Okay.
Saudia,
I was just curious on the abandonment. If the person dies in between this process, does their family get access to their belongings?
I have
don't
seen
see
lots of.
why not, but
I've seen a lot of cases where they tape it up and you can't go in there until the
Unless it's a
whole
will.
the whole probate, blah, 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 blah.
Okay, I was
you
just,
have to go, it's probate, Saudia. I
well,
think.
well, I'm talking about in this, because we're talking about if they abandon it and when the landlord can throw away their things. So if the landlord's in the middle of this process, and let's say the sheriff comes and the person takes their life, when the sheriff comes, the landlord would then be responsible to give the property to the family member, correct?
the property at that point would become part of the estate for the individual who has deceased.
Okay,
Yeah. Well, they're having an estate either way.
okay, thank you.
I do not, I don't know in statute what, if I were the landlord, I assume you would be able to remove the property and put it in a storage unit and then allow the estate to come.
That's exactly, I had that happen. Actually, when do I dare mention the store? I had that happen. The original tenant died and several people claimed to us that they were the inheritors. And the court, we wrote the court or called the court and said, what should we do? And we stored it. And the court, the parties never agreed on who it was. And so we finally just wrote the court saying in 15 days, we're getting rid of it. And then they finally said, go ahead. I mean, it was, so anyway. Okay,
So there's one other piece that we have not kind of walked through in detail, and I don't know whether anyone wants to or feels like you need to. There are the sections at the very end regarding the pilot rental payment pilot program. Mr. Chair, I know you mentioned at the very beginning, this was kind of language that had been worked through quite extensively last session to address a lot of the concerns that have been raised at the time. Just flagging that it is there. And there is one change towards the bottom in the appropriations section. The treasurer's office asked for a clarification on the appropriation to the treasurer's office because it comes with $100,000 to administer. Just clarifying that that also allows them to contract. So $100,000 for contract administrative costs necessary to implement that program. I don't see that as necessarily a substantive change because I think that was the intent from the beginning to administer the program. They get this money, they wanted that clarification. So I'm just highlighting it for you all because it's a change from the bill as it was introduced.
and there's the 600,000 for OEO.
Which I have not included yet because.
I gave you the best we got.
Yes, and I'll take a look at it.
So let's talk about process for tomorrow. Actually, I think we all pretty much know what's in the bill, but I think it's important that people see a final bill. So what's, Marion, help me out. What can we do tomorrow?
Well, if you set the parameters of what are the changes proposed that came out of today that we've asked Cameron to
I
make?
think there are very few, actually. We decided much of it. I checked certain areas that where we went one way or the other. Just so people can just, when we have a discussion, we can flag them if we want, but I think pretty much Cameron can draft a final version. Question is whether people want to vote for it.
Yeah, the changes for today are if there's a week-to-week rental going from 10 to 7, excuse me, going from 7 to 10, if it's a week-to-week, to align it with the non-payment of rent section. And then there was
Just the weekly rental.
For weekly rentals,
if you're on a week-to-week basis,
yes,
what is the notice period for
okay,
terminating that?
okay,
And
it used to be.
Currently, it's 7
Okay,
and going to 10.
okay,
Which has been consistent with other notices.
And then there was the period where if a landlord is bringing the ejectment action, how long do they have to bring that after providing the termination?
We decided to stay with 60
If it
days.
is 60, there was some
Remember that? You're
changes.
looking,
Different question.
you got it?
No, no, well, I mean,
You're not, no, oh, maybe you weren't in the room.
what you,
The issue
make
was,
sure I got it.
right now, under current law, I'm just gonna say this really quickly. Under current law, a landlord has to bring their action. If they're gonna bring an action for non-payment of rent, they gotta bring it within 60 days.
Okay,
That was shortened to 30. I'm not sure why. Because the person who wrote that provision is a landlord advocate. Debbie said, wait a minute, actually 60 is good because we use that period to try to negotiate. The tenant and the landlord try to negotiate a possible solution. And also it's more time for the tenant. So we said, okay, leave it at 60. This is, in other words, the landlord has to they can bring the action in 5 days if they want, but they have to wait.
they
You have to do
they
it within 60. Okay, go on.
And so then the next piece I have is for the section here, when you are giving the tenant a defense to an ejectment because of the health violations, to add in there something about the landlord making steps to cure.
Yeah, substantial progress, right? Yeah, okay.
And then the next change that I have is cleaning up. Going with one of the two sub As under
Right,
this section, that's technical cleanup for me. The discussion we were just having about how long the landlord keeps the property after the given legal possession again. Cleaning that up even further. And then I have the getting rid of the reference to just cause, getting rid of the removal of the right to a jury trial, and then those are today's edits based on what we've looked at.
You look like you're ready to speak.
Yeah, John, just coming, so we changed the week to week from 7 days to 10 days to make it consistent with not payment rent, with said 10 days. Is it?
There aren't many week to weeks, but there are some.
Yeah. But I'm thinking back to the non-payment of rent and thinking it probably shouldn't be 10 days. And the reason I'm thinking that is, one, the sooner they get the notice, the sooner they can start applying for help that they need, and it's not a surprise. I mean, they'll know whether they.
What is
rent
the
or not.
10, what is the 10 days?
The 10 days is the period that the tenant has before the termination date. So it's saying that you have to give them a minimum of 10 days before the rental agreement is terminated. So you could give them 20, it's currently 14, and this is lowering it to 10.
In other words, this is before any ejectment action. This is just about the notice to the tenant. It's over as of this date. And if the tenant hasn't paid rent, you can call them up, you can tell them they haven't paid the rent, they have a contractual obligation to pay the rent on the first. But when you can send them a notice and you say in the notice, they don't pay on the first. You send them a notice on the second and say, this terminates the tenancy, which on the 12th. In other words, you have to say it terminates 10 days, but they're on notice. I mean, they're on notice the minute you do it.
And pass the paper that they need to go on that person.
Right, a termination notice is what they need. Yes. Yes, Debbie.
Well, but we've added 5 days for mailing. If they won't accept it by hand. We have 5 days for mailing, so you're up to 15 days, really 16, because you have to you start counting the next day. And then 17 before you can bring action. And right now, we've got basically 19 days. It's not that much different. Because we have 3 days for mailing now with a 14-day notice.
So
I'm not,
Okay.
So how many days are we quibbling over? Just so I have
Well,
it clear, I'm trying to
Well, I'm
understand.
just saying if we did
It's just
3 days
whether or
and then
not
you're
to
adding
use
5 days for the mailing, we're at the 7 days that Mark was talking about in the beginning.
Right. All that's happening though is the moment you give them the notice, okay, they know. However you give it to them, they know. And then the question is, and once you give them the notice, they've got it and they can go to I'm just responding, they go to any entity they want. But I need to stop here and say 2 things. We are gonna, because we have the floor in 5 minutes.
and
We're
then
gonna
only
meet
start.
we're gonna meet tomorrow morning at 9 o'clock. Our council will have a revised version, okay? We can discuss it and take whatever action we want after that, and I'd like you to clear our calendar so that we can do that. And what's your availability? Do you even know?
Yeah, I am good tomorrow.
Good.
You are
Good.
hours.
All day.
Yeah, we need you all day.
I
Did
was
you
just
get
saying-
my amendments? No, I'm just kidding.
Oh, you had a heart attack.
I will say, I will remind you that at a point, it has to be edited again.
Right,
Right.
probably 2 more
So,
times,
um,
maybe 3.
I will not have it edited before tomorrow at 9.
Right,
So
okay.
I'll come in, we can review it, potentially make some additional alterations. I mean, you all make alterations whenever you want, but just if you're wanting it out by a certain time, just remember I will need to take whatever version that is, have our editing team review it.
I don't, that actually, at this point, where we are, I'm not worried about that, because we can meet tomorrow at 9. We can go over it, we can discuss, we can talk about problems we have. He can disappear, we can keep talking,
That's fine.
and we can keep talking, and then he'll come back with the final version, and we can vote on it if we want.
But I would like the committee to know that I personally will be ready to vote and calling it to a vote soon.
You might ask, I think it's perfectly,
No, I'm
You
done
might ask-
crying.
yeah, you might ask, what's the rush, right?
I don't think it's even been a rush.
Well, I'm gonna talk about that for 1 minute. In fact, 30 seconds. One, it has to go in some form to the judiciary. Number two, it has to go to appropriations. Number three, then if it gets out on the floor and is voted out, it has to go to the Senate.
Ugh,
And it will be heard all over again in the Senate, okay? And finally, if it gets out of the Senate and the governor signs it, next session, I have a cleanup bill, I guarantee.
and no, it comes to us again before the governor.
Yeah,
We have
You
to
get it back.
confer with those
yeah,
senators.
right.
So it's got a road, so
Does
that's
it
why
Pick
I'm,
it up in the other committees?
But
Do they have to pick it up in the other committees?
they may,
Well, they
it may
can
be a
choose not to.
flyby, or it may be, they may take possession.
and they may claw at it too, so anyway, I just wanted people to know that I'm personally gonna
That's,
be
that's
making
the
this.
reason, yeah, that's the reason I want to move
Gotta give it.
Yeah.
sooner rather than later. Thank you, everybody.
And a particular thank you to Cameron.
Yeah. Yes, we are adjourned.